Hello, fellow Toolboxers. Welcome to episode number 362 of the Immigration Lawyers Podcast. The numbers are really getting up there, and we're going to go really big this year, doing a lot of different podcasts and interviews coming up. So prepare for that. Before we start, I want to mention really happily that we got also the next issue of the Immigration Lawyers Toolbox magazine out. Issue number 8 was published about a month ago. Haven't had a chance to really tell people about it, but it's really cool. We had a lot of colleagues get some good information, and it's free. To access it, just go to iltbox.com or immigrationlawyerstoolbox.com, whichever you like to prefer, and go to the magazine page, and issue number 8 will be there. We're trying to get issue number 9 out probably in March, so that's going to be a lot of fun. If you know a topic really well in immigration law and you wanted to share with our colleagues, let me know. Send the idea for an article. It's 2 or 3 pages. You don't necessarily need to have citations. It's not a scientific paper, but we like to really just get some good information that's different. That people could help and make sure it's not previously used. So just reach out to me, info@immigrationlawyerstoolbox.com. That's the email, info@immigrationlawyerstoolbox.com. And we'll try to get you into more content, the better, to help our field get better. And speaking of helping the field get better, our regular training course is regular now about E2 visas is coming up on February 20th. So those haven't done E2s or done it a little bit or not comfortable, we're going to go over a case, change of status, less than $100,000 investment for a guy who made a real estate development management company of less than $100,000 investment, or honestly less than, I think, $70,000 investment. And it was approved, change of status with premium processing. So we're going to go over the details of that case. If you're interested, we have a link for signing up, but just email me first, let me know you're there, and then I can send you the link. I will reply with the link. It's coming up, it's a Thursday at 10 a.m. Pacific, 1 p.m. Pacific, to 1 p.m. Eastern, the 20th, I believe. So get it quick because that space is filling up. And we're also going to do a national interest waiver course. I redacted one case for March. I got to go over the reaction, see how much I can share and stuff. But that's coming up. So if you're interested in this kind of a 1-hour training session, 45 minutes an hour, one-off training session, let me know. It's $275 right now. So it's not too bad to learn a whole new skill. Definitely worth it. Having said that, our discussion today is with our wonderful Gregg of the Immigration Review Podcast. He's on a regular monthly here. We're going to discuss a few cases that came out in January and just talking about the stresses of being an immigration lawyer during the Trump period, being an immigrant during the Trump period, and it's just the beginning. So have fun with this conversation. As always, none of the information provided here is intended as individual legal guidance. Please consult with a lawyer, but y'all know that already. Hello, Gregg of the Immigration Review Podcast. How are you?
I'm doing well. Sorry, I'm a little dark. As we're in my office here, the sun at the 3:30 hour comes directly in from the west and makes for weird lighting. So sorry about that to everybody who's watching and to you who has to watch me in real time.
That's all right. By the way, you're in San Diego, close to the border. Are you running into like checkpoints down when you're driving around and stuff?
No, I mean I'd love to. I would relish that experience, unless I was in a rush for some reason. But one moment. But no, I things are weird and scary in San Diego for our clients and a lot of the nonprofits down here who work in that community. I don't have a lot of that community as clients, as you know, our firm is also based in Miami, and so we're getting a lot of scared people calling and a lot of our clients. And I do have a detained client who we have a petition for review pending. It's ripe. We're waiting for a decision, but the U.S. government is trying to take steps to remove that individual, even though the case is pending. They're going to make me file a stay motion. So, everything is getting quite serious, scary. Had to write multiple emails to clients, assuring them that, what your children are U.S. citizens. Thank God for the ACLU, and also I don't actually know how it's going to all play out.
Yeah.
So these are scary times, and I'm happy to be in it for people. But I'm really upset that it got to this point. I
Yeah.
guess is where I'm at.
Yeah, I actually got a call from local to you, and I gave the guy your information, but he had
Oh yeah.
cancellation removal, and he's like, "Is that going to go away?" I'm like, "Well, you asked the wrong guy because I've never dealt with cancellation removal, but probably not. I mean, cancellation removal can happen depending on like country conditions changing. It depends on why they got cancellation, I guess. But
No, they can't take away cancellation unless the guy gets another conviction that disqualifies him. Um, Even if they get rid of cancellation under the statute, he would still have it. He's quite protected, although he should naturalize as soon as he's eligible. It used to be guys like me, like we'd fight, and we've got all our arguments, but we are now in another world where not only do we seem to have a president and executive completely untethered to the law and willing to bend the law to the point of breaking in immigration and other issues, but we have a Congress willing to pass draconian statutes.
Yeah.
The Lake and Riley Act that just passed is horrific. And what happened to Miss Riley is horrific, and my heart breaks for her and her family. But it does not seem to me, at least, that these two things are really connected. That the perpetrator was a Venezuelan with a theft arrest. I don't think that statistically that is relevant. If we want to talk statistics, everyone knows the immigrant community commits far less crimes than does the U.S. citizen community in America. And so the fact that a mandatory detention bill passed and was signed by the president that mandates detention without a bond for people that are simply arrested or even charged, or I guess even admit to having commit something as low level as a petty theft is quite frankly mind boggling. And if that can get through Congress, quite frankly, anything can.
Is it
And it's
like
very
if they add
scary
a
for me.
status, or if who does it apply to? Certain types of non-immigrants?
It
Or
applies to EWEs, people who are A7, so they overstayed their parole, or people, which, and this just makes no sense, people who've committed a misrepresentation of the government or who have falsely claimed to be U.S. citizens. Like, why 212A6 is part of that makes no. It just goes to show that it's just anti-immigrant forces trying to do everything they can. Here's the scary thing that I keep talking about. He already got rid of TPS for, well, he tried. We'll see what happens. But he already got rid of TPS for Venezuela. We know he's coming for all the TPSs, and he's going to come for DACA again. You remain eligible for TPS or DACA, as you know, if you have one conviction. Forget about arrest, like even one conviction. So once he gets rid, and most of these DACAs and TPSers are A6 or A7. They're either EWEs or or they didn't have valid documents.
mm-hmm.
Once DACA and the TPSs go away overnight, he's going to transform. As we know, there's like 1 million DACA people. Like over 1 million people are going to not have their pseudo status anymore. But a large subset of them, tens of thousands probably, are going to be subject to mandatory detention because they're an A6 or an A7. And let's be honest, some of them probably have an arrest from 15 years ago,
Yeah.
like the DACAs. Like they did something stupid. They took a shirt from Hot Topic at 19 years old. Now they're a 40-year-old person with a family. That arrest from the Hot Topic shirt didn't result in a conviction, didn't even result in a charge, but they were arrested. That arrest from possibly 20 years ago will result in a DACA person without any conviction being subject to mandatory detention the second they lose DACA. Arguably, right now, to be honest with you, it's just you probably couldn't hold that person because they're not removable because they have DACA. So, what just happened, and no one was talking about that, although I was screaming it to anyone who would listen, what just happened is crazy, and it's going to tear families apart for reasons completely untethered to what the tragedy that befell Miss Riley. And I'm just gonna keep saying this because we're gonna see it, and
Yeah.
it happened because they allowed things to pass Congress.
It happened out of blue between the election and the coronation, like, or whatever they call it, the inauguration. Uh,
The coronation. Yeah.
so I was surprised. Like I was like it was during Biden's time. It was voted on, and then I thought it was just one of those things going to disappear. It was kind of weird thing. I didn't believe it was going to go through.
Well, it's because the Senate gets a new leader before the president is sworn in. So Leader Thune was either going to try to force Biden's hand or just get it ready for Trump. But the fact that the Democrats had far more votes to get it out of committee and to break a filibuster
Yeah.
without even any amendments, except even more draconian amendments, is very telling. It's very telling. This will only, there's other legislation already coming, and there will probably be more. This is it's quite scary for a litigator like me too. Once Congress starts getting in the anti-immigration game,
And that
then
could
your
go
only hope
after races. Yeah.
is the Supreme Court and constitutional challenges, unless they write a bad statute that you can play with. Um, if they can pass mandatory detention for petty theft arrest, I don't even know what we're doing anymore.
Have there
With
been
it,
laws?
with by the way, without a limiting principle, without any statute, it could be a 50-year-old arrest under the statute. It looks like mandatory detention
If they
without
get
even
rid
a
of even
bond hearing.
DACA, like, I mean, this stuff's horrible, but like all of a sudden, there's companies that I have clients that are working at big companies and big roles. Like, all of a sudden, a million people are going to be yanked out of a job. That's going to be super
Yeah,
disruptive towards like commerce in the whole
yeah.
country.
No, DACA's not gone yet. I just want to. I'm just
Yeah. No,
putting
if
that
they
out
try to get
there.
rid of it like that, so it's going to be a deal. I mean, because it's. I mean, then again, this guy's like trying to do tariffs with Canada and Mexico. I mean, it might be a tactic, but it's like it's like playing one of those old school things where they have the car, they go off a cliff, who could stop playing chicken. It's a dangerous game of chicken to play.
You got rid of DACA last time, and the Supreme Court saved it. It was
Yeah,
just John Roberts with a different Supreme Court. I mean, I didn't see a big grand bargain last time, and if I recall, the Dems had the House. So I'm
yeah,
not as confident as you are that there is a grand bargain out there for the DACA people, and that's
yeah,
just a small. I mean, that's just a small component of immigration.
yeah. I think when
It boggles my mind that there was a filibuster proof amount of Democrats willing to pass such a draconian immigration bill and didn't ask for any of the things they usually, like the
yeah.
DACA resolution, anything, that there was no, they didn't even attempt to make a deal. I mean, I thought that's the whole point. Like, you're supposed to make deals, right? One side wants something, the other side wants something. I mean, they didn't even try.
What's
And
been a theme of our conversation? The Democratic Party doesn't care about immigration. It's just the talk. They don't care at all. I think they're more like go either way for them. Like,
Yeah, some do. I think that they walked away from the election under the belief that it's a losing issue for them, but I think it's losing issue because of how they've been talking about it.
yeah, it has to be
Um,
positioned the right way. They picked like the worst examples. A lot of, I mean, it's going to pause, but worst examples of like they're dying on the wrong hills of immigration. There's all sorts. It just the way they put the issue out there is always like a loser way to do it. But I mean, you see from the fruits of the elections that I'm probably right, but it is what it is, I guess. So what do we have? Speaking of Supreme Court, what do we have today in federal litigation?
no, I mean, we are. This is the first time we've talked since the inauguration, so
Yeah.
let's try not to be so negative. I'll pull. I got two good ones. There's some other good ones too, but these ones caught my eye. First is Akinsanya v. Garland out of the First Circuit on January 10th, and this one was litigated, or at least ACLU New Hampshire was involved, as was Benjamin Osorio. So those two, setting up Kim and ACLU New Hampshire and Benjamin Osorio, they really are making really good law in the First Circuit for non-citizens, particularly in the Convention Against Torture context, and that's what this is about. Mr. Akinsanya was a police officer in Nigeria, who was put to the north and went against Boko Haram, and then Boko Haram started doing things against him and his family,
Hmm.
and all this stuff. And then he came to America, did a bad crime, and so only cat protection is on the table. And it is no secret. I think it is generally understood that the Nigerian government is not in league with Boko Haram. I mean, they're trying to do some stuff. I mean, some elements of the Nigerian government might be, but like, it's not. They are fighting Boko Haram, at least at points. I'm no expert on Nigeria,
Hmm.
but Convention Against Torture requires a showing that the government will acquiesce or consent to the torture you fear. And what does that mean? And this is why this is so important. The First Circuit said that in order to deny a Convention Against Torture claim, an immigration judge must first describe and list out what the foreign governments duty to intervene is in that country. So, as I read it, like an immigration judge needs to look at a country and decide what specific duty this government, considering all things with this government, has towards people, in this case, Nigeria, towards people who are scared of Boko Haram. And then, only then, can the immigration judge consider whether the steps taken, if any, satisfy that duty. A two-step process. And that is a big deal because with Convention Against Torture Protection denials, it is often the case that an immigration judge and the BIA will say, well, the government has taken some action. They're fighting the gangs. They're doing this. They did this in 2023. They were not going to consent or acquiesce. They're fighting. And just the fact that they don't have enough resources to be successful doesn't mean that they're consenting or acquiescing. But that is not the law in the First Circuit, at least after this decision. Quote, a no acquiescence finding cannot rest solely on the fact that the government has taken some responsive action to combat private violence. There have to, the agency, quote, the agency must explain why the government's steps, though inadequate or ineffectual, nevertheless satisfy its duty to intervene, end quote. So that is a bit of a seismic shift. Consent or acquiescence focus is really about whether the government has satisfied their duty to intervene and protect their residents. That's a big deal. It's kind of coming from United Nations regulations or laws or however they work. And so check this out in the First Circuit and in other circuits. Try to spread it to your circuit because it's a big deal and it's a big protection for Convention Against Torture applicants.
So you're saying in these cases the judge has to do extra work to study the country conditions, or is it like the TA does it? Or they call them TA.
Well, that's always been the case. I mean, it's interesting, right? Because Convention Against Torture Protection, that is the non-citizen's burden to show they warranted, right? But the First Circuit is saying the immigration judge has a duty to identify as a matter of law. I mean, the judge always has the legal burden, right? They have to no both parties could come in and say nothing and the judge would have to say, well, here are the elements of what they want and here's why you don't meet it. I mean, that's
Yeah.
what a judge does. That's not how law should work, but that's always the judge's burden, if you want to call it a burden. And here the First Circuit is saying this is what's required. As a matter of law, an immigration judge must first explain what the duty to intervene is of a country's government.
So you're saying like sorry, I'm just completely ignorant on this. So when you say duty, do they have to specifically go like they like in general say a government should do this in hypothetical like theoretical words, or do you saying like the government of Nigeria should be doing this, or how specific?
I'm not gonna lie, I'm not sure. I was left wanting a little bit by this First Circuit decision. This is the first salvo, as so often happens.
Okay, I'm
In
not okay. I'm like how am I
Garland.
like okay, it's not just me.
No, it's how does this work in practice? I don't really know. And what happens if an applicant submits no evidence on a country conditions? You're right. How can an immigration judge make that determination? Nevertheless, they have that burden, they have that duty, the immigration judge, to define what the duty of intervene is in a specific government in a specific case.
It's kind of
According to
open
this
ended because it
decision.
was like it leaves up to massive inconsistency in the First Circuit. Then judges do different things, like or
Well, that's always the case in asylum law and in all immigration law. I mean, you
yeah,
can have some judges who think that a DUI is always going to make someone a danger to the community and deny bond, which we have all over this country.
yeah.
And then other judges who don't think that. You're going to have some judges who think that victims of domestic violence in Guatemala are a cognizable particular social group, and some judges who don't. So I do think that issue is par for the course in removal proceedings.
Yeah, unfortunately. Well, speaking of removal proceedings, they're saying like they're gonna let ICE come into removal proceedings to just check what's going on. What does that mean for people who have hearings that day? Do they just pick them up afterwards if they show up to a hearing? If is it just make it easy picking for them, or how does that work?
I mean, look, ICE has always had the authority to detain whoever they want in
Yeah.
immigration court. I mean, anybody can be detained in immigration court.
Mm-hmm.
Um, it's not practical because if they are clearly not dangerous or a flight risk, they're going to get released because they're due a bond. But I mean, that still rips families apart for a couple of weeks, and it costs
Yeah.
thousands of dollars to get a bond packet together. But now, after Lake and Riley, that has changed. There are probably thousands of people, maybe tens of thousands of people, to be honest with you, in non detained removal proceedings right now
Hmm.
that just became mandatory detention. And that is a scary thing and completely impractical, right? Because you've got people who have been in non detained removal proceedings for years
Yeah.
who are not dangerous, who, if they had gotten a bond hearing 3 weeks ago, would have been found to be not dangerous. Hell, maybe they already got a bond hearing and were found to be non dangerous. But now, because Congress has changed the law, they are presumed so dangerous, possibly because of a petty theft arrest 15 years ago, that they are now subject to mandatory detention, and their case is going to be transferred to the detained docket. Again, we're only talking about EWIs, A7s, on misreps and false claims of citizenship people, but still. So, in practical speaking, that transfers a lot of asylum and a lot of non LPR cancellation of removal cases to the detained setting, where things speed up a mile a minute, and it's very hard to work with your client. It's very hard for your client to get evidence. That is what Lake and Riley has done. And that's one reason that ICE is hanging around removal proceedings. Additionally, the executive order or ICE guidance has instructed ICE to terminate proceedings to the maximum extent possible where the individuals are actually subject to expedited removal. And the Trump administration has said they want to do expedited removal to everyone who's been here for less than 2 years, as they believe is their right under the statute and regulations. So I think that's another reason ICE is hanging out in removal proceedings. You have someone who hasn't been here 2 years yet, they're in danger of having the ICE TA terminate and ICE detain, and then ICE ordering them removed themselves.
Dang.
I suppose, unless they have a credible fear, at which point you're back in removal proceedings.
So we have like five
The
percent
whole
of the
thing is
population and
wild.
completely freaking out right now. Like,
I would be freaking out.
yeah.
They should be freaking out. Immigrants have become the national enemy of this country, which is a very scary thing to have a national enemy. I think history shows what happens when you deem a group of people the other or the enemy. And it's one of the reasons I became an immigration attorney in the first place. I returned to immigration during the first Trump, at the beginning of the first Trump administration, because of what happens to a society, both immigrant and not immigrant, when you label an entire class of people as the other. And I think we're seeing it right now.
Okay.
Not ready for this, huh? I'm sorry. I mean, you're catching me at the beginning of February 4th, 2025. It's been a raw couple of weeks.
Yeah, yeah. The thing is, I don't. As I've said before, I put stuff out of sight, out of mind. So you bring it up from out of mind to the front of mind. Like I deal with people calling me
Well,
right now, and
that's
I'm just,
my bad.
yeah, no, it's realistic. It is what it is. I mean, a lot of people tune in to hear reality of it. So it is what it is. Is that I'm
I mean,
so
as we speak, it's been reported that we are shipping people from America to Guantanamo Bay
yeah, that's a mess
in
up
military
situation.
planes.
Potentially them doing a deal with El Salvador to even send U.S. citizens there. That's got to be struck down. You can't just send U.S. citizens to overseas prisons. That's kind of a crazy situation.
I mean, the fact that we're even having these conversations just shows how far we've come and how we just keep shifting to more and more and more authoritarian and how things become normalized. I mean, these conversations would have been impossible to have in 2015, but we have shifted so far that it is not. I mean, it's barely you barely even hear a peep about shipping U.S. citizens off to El Salvador, even if they're just trying to muddy the water and get clicks. When Marco Rubio comes on TV and says that this is a good thing, it's not even really being challenged because we've normalized so much in the last decade.
Yeah, America's been pretty crazy for the last 10. I mean, last 10. You know what it is though? Like I thought the 90s were really cool. This is kind of off tangent, but I'm like, well, 90s were so like better because that's where I grew up as a kid. Then I realized 90s had people were burning places down. So it's been a lot of craziness consistently. In California in the 90s, they passed that anti-immigration law that was struck down. some sort of direct, what is it called? One of the direct democracy things they do in California. So,
Yeah.
but I guess it's a different level now, a different level.
It's a good point. I sometimes wonder about this too. Like, do we freak out more because information is so much easier to accept to obtain that we're constantly getting notifications on our phone on things that in the past might not even be reported, or if they were on the nightly news with a million other things. Is that the case, or is this really different? I think it's both.
Yeah, it is
I think
both.
it's
It is,
both.
yeah, it's both. Because in a sense, like raids are happening, but they're happening before too. If people were talking about it more effectively, it'd be during Biden's time. Probably the number's gone up, probably 20, 30%. But it just, immigration lawyers on Facebook were constantly, as soon as some person hears about one school, everyone hears about it. It goes in the other direction too. Back to 4 years ago when like there was, LGBTQ transgender thing, when one person had one thing happen, and then half the country would blow up and say, "Oh man, it's taking over the country." I kind of so it's like there's a little bit of both at the same time. It is happening. I mean, people are getting picked up. Lincoln Riley did happen, and no one said anything. This is kind of crazy bill. So
I think this is different than the first Trump administration. I think they know exactly what to do, and I think we're seeing what they would have done if they had been elected to a second term after they learned so much, and it's actually even more now because now they got to reset, and now the administration can act like they have a
mhm.
mandate, and like they are righting a wrong that the Biden administration did, which I don't agree with, but I do think that this is different. We don't have the same people, the adults in the room, the people who care about government functioning. We're I think we're witnessing a revolution. We're in the middle of it.
It's a reset.
Immigration is just
Yeah, it's a
one
big reset
component.
happening. Of
I don't agree with the revolution.
Well, the thing about when these resets revolution happens, like whatever starts it, it never ends up. I mean, it's usually up terrible, but it goes. It's like if you have a hose of water and just turn it on max, the hose just shoots out. It goes like a snake shoot, like going everywhere. Once you unleash these kind of forces, I think whoever is in charge never would happen because the country's been every 45 years, 50 years, there has to be some sort of change is happening, and we've kind of been stagnant. Um, it's just a reset's happening, but it's going to bring out the reality of what the country is inevitably, whatever way it is, and we're going to put the true face of it
Yeah,
on.
I guess if we were going to see a reset and a change, I was hoping it was going to be more akin to the '60s, and caring for one's fellow man and peace, love, and economic fairness, and not right wing individualism, every man for themselves, create a national enemy. It's unfortunate that this is the revolution that a lot of America, that the loudest voices in America want.
So, case number two.
Hey, you've got the editing
No,
capability.
it makes for fun radio.
Aguilar Quintanilla v. McHenry, published by the Fifth Circuit on January 24th. That is Acting Attorney General James McHenry, who was the EYR director during the Trump administration, who, as I mentioned on the podcast, and I don't have proof of this, but I'm pretty sure was only able to be acting Attorney General while we wait for Pam Bondi because the Biden administration allowed Mr. McHenry to remain in the Department of Justice. During 4 years, they shipped him off to Okaho, where he issued some pretty rough decisions, in my opinion. But the Biden administration was not going to take retribution on Trump people. Let Mr. McHenry keep his job or a job in DOJ, a pretty prominent job in DOJ. And because of that, I believe he was eligible to serve in an acting attorney general role. And in that role, has not extended the same courtesy to other DOJ employees. And we are seeing mass firings and pressure campaigns of DOJ employees with much more to come. But so the irony is not lost on me that Mr. McHenry is in this role because what he, at the behest of his boss, is doing to DOJ employees was not done to him.
I mean, they should have cleaned. Biden should have cleaned house when he came. They've done the BIA stuff the same. That was just like stupid. Like,
I don't want to be in a country where I don't want to be in a country where every time an administration comes in, they take away people's jobs and it shifts so sporadically. That doesn't end well. But it does seem that the Trump administration, especially now, and their allies are playing that by those rules, but the Democrats are not. And I still don't want them to do that. That is chaos, and these are real people's lives. All the attorney general honors programs positions that they revoked. These are real people, high achieving law students. If they're going to get rid of all of the EOIR employees who are on their 2-year probation, judges and attorney advisors, which is
I mean,
quite frankly
those
even
I
more
would
than
keep. I
room
mean,
at
it's
this
on the
point.
pyramid, but like on the top people that are semi-political chosen, like those are rotating things. Now, the way the BI was being manipulated in the last administration, I mean, last Trump administration, where he was kind of packing it and then giving the deals for people to retire and stuff like that, a little bit too much. But at the same time, they cut down a little bit of that Biden administration. You have some package deals for people to retire.
Yeah, well, right. I mean, I think a couple left, but no, I mean, the Biden, let's call a spade a spade. The Trump administration expanded the BIA and then packed it.
Yeah,
I mean, once that's court packing.
yeah,
They said
straight
the
up court
Dems want to
packing.
do court packing. They actually did do court packing. It's really par for the course to use that metaphor for a second time. Like what Trump does is he accuses the other side of doing what he actually wants to do or has done. That's how his mind works, it seems. Anyway, Aguilar Quintanilla v. McHenry. We'll have a couple more McHenrys, I think, before Pam Bondi is confirmed. Thank God it's not Matt Gaetz. Is out of the Fifth Circuit,
That would have been a
and it's
show.
about gang-based cases from El Salvador. It's another Convention Against Torture case. And this one, first of all, it's quite interesting, the procedural history. So Mr. Aguilar Quintanilla, he actually had a removal order that was executed, and then he came back illegally, and it was reinstated by ICE, meaning he was only eligible for withholding of removal, put in withholding only proceedings. But then ICE inadvertently leaked his personal identity information on an ICE website, which, and to their credit, I don't know. I don't know why the two things are really connected, but like, you know what? That was so bad. We're going to terminate your withholding only proceedings and put you in regular removal proceedings, where, of course, you can apply for asylum as well. Which just, I mean, good on you, ICE, for trying to right an inadvertent wrong. But also, like, ICE always has the discretion not to reinstate.
Yeah.
And it's good. It's nice seeing a case where that is actually exercised. But the thing is, as well, is it does seem that Mr. Aguilar Quintanilla is or was gang affiliated. Got some tattoos and stuff. And he was alleging a fear of both the gangs and the Salvadoran government. And he lost, and he filed for a stay of removal before the Fifth Circuit while his petition for review was pending. And the Fifth Circuit, as they so often do, denied the stay. And so he was deported while his petition for review was pending. And let me just quote from the decision. Quote, the next day, El Salvador's Ministry of Justice and Public Security published a picture online of Aguilar Quintanilla on his knees between armed members of the National Police. End quote. But the Fifth Circuit just kind of mentions that in a footnote. But like that's what's at stake when these stays are denied. And now he's got to come back because he just won his petition for review at the Fifth Circuit. If he's alive, the decision does not say. And that is because the country condition in El Salvador, the country condition evidence, plus his criminal record and his tattoos, and the fact that they were searching for him at his father's home, the reasonable conclusion is they would more likely than not be tortured by Salvadoran security forces if returned to El Salvador. And that, I'm sure, and like it's not legally relevant because that's not part of the record that the Fifth Circuit's reviewing, but I'm sure that picture on the Salvadoran government's website had something to do with it.
Wow.
Now here, I do believe, I can't remember if he was found not credible. I feel, let's make sure.
By the way, everyone, you could get notes on this on the Courage Band website, KKTPLAW.
That's right.
Immigration Review Notes. Are you selling it? Is it free?
That's free. Thanks for filling in there. I actually don't think he was deemed not credible, but even if he was, you can still get cat protection, even if you're not credible, end quote. The CAT regulations require the IJ to consider affidavits in the likelihood of torture analysis, end quote. I do believe he was deemed not credible, and the immigration judge therefore didn't want to consider these affidavits submitted by other people on his behalf. But you can't do that. Quote, he was not credible. Quote, there is no exception for cases of adverse credibility determinations, end quote. Now, maybe these affidavits are less reliable, especially if they rely on the person's credibility who a judge has just deemed not credible. But an affidavit's a strong thing.
Mm-hmm.
And because CAT is a totality of the circumstances analysis and can't be denied simply based on adverse credibility, they must be considered. And that's the main reason this is going back, Aguilar Quintanilla. So that's a powerful thing, too. The power of affidavits in the Fifth Circuit, even for a probable gang member with a criminal record who has already been deported to El Salvador and who has been deemed not credible. Still, affidavits are exceptionally powerful, even in the Fifth Circuit. Aguilar Quintanilla v. McHenry.
Good to know. When I mentioned the notes that you took, you could take that all and make a PDF, create a GPT online, and people could go and ask questions, and it'll be the knowledge base for it to answer questions. So they could do a search and answer and just figure it out for you.
Well, that's a good. I wonder if Gregg Siskin has already, stolen it up, gobbled it up.
I would do that for him. I'm gonna do that for the Toolbox right now.
Yeah.
But yeah, create a GPT.
It's Gregg Siskin. It's not Jeff Joseph, right?
Jeff Joseph. They partnered up for that thing.
The AI, right? But no, I've thought of maybe selling the transcripts. It's just an endeavor, more work. Hopefully we can do it someday. But I want to keep the notes, the bullets free because it's become quite the resource for the immigration community. And, it's hard enough out there for us.
Yeah. Well, you get the transcripts, download them all, and then put into GPT, and you could charge for it even, and people could access that GPT and just ask questions, and it'll pull up the episode and all the notes for it. Either free or whatever. It's worth it. People do that kind of work that you're doing, they need these kind of resources. It'll be cheaper than
I don't
Lexus
feel
or something
comfortable. I don't feel comfortable with people relying on me for case law research. I like to think of myself as a starting point.
It's a starting
point. I understand the reality.
They're going to go to ChatGPT anyways. Might as well have a better knowledge base on it.
That's a decent point.
Well, very cool. Thanks for coming on the show again. Appreciate it, Kevin Gregg. Immigration Review Podcast, found wherever podcasts can be found. And do you have a YouTube page for your podcast too? I think it's no visual, but it's audio on the podcast on YouTube.
That's right. Well, that's because Google got rid of Google Podcasts and transferred everything into YouTube. So I did do that, but I'm not doing anything special with it. I'm just using that as the way to also have a podcast in the Google community. I'm not sure if it's working. But I've got a lot of good subscribers, and I'm happy to be doing it. I'm over 4, and I'm almost 5 years in at this point.
Yeah, it's legit.
Episode 250 drops on Monday, and that's just the case law stuff. The interviews, which I haven't done since July, puts probably us at like 270. It's wild. That's why I like talking to you.
Good stuff. I'll come back on pretty soon sometime and check out your audience. But Kevin, thank you so much for coming on. I really appreciate it.
My pleasure. Sorry for going to 100 immediately.
No, it's good. It's fun. I was good to talk about different stuff. Thanks, bro. Thank you, everyone, for listening. What a wonderful guest we have. It's so kind of him to come on our podcast. And if you haven't already, check out the Immigration Review Podcast. It really goes over really in depth, even more here with all the immigration federal court cases. It's amazing he has the time to do that with his busy schedule. Kevin's a true gem in our field. If you haven't already checked out the magazine, the Toolbox magazine, go to iltbox.com. Check out the magazine league for the new edition, and check out the E2 course and the NIW course that's upcoming. Email me, info@immigrationlawyerstoolbox.com. Not sure if it's a course or a seminar. Seminar makes more sense, but we go over actual cases, redacted, so you get real practical stuff. Not like all the other seminars where they just talk in the clouds and stuff like that. You see real stuff. And so it's going to be really helpful. I think everyone's been happy he's done it so far. We got a lot of repeat users coming back for other sessions. So if they're coming back for more, that means it's good. Email me at info@immigrationlawyerstoolbox.com to get in. Lawyers only. Have a good one.